how does a Texas divorce work? This is information that I've been wanting to get down on video for years. I've sold this information to people for decades, but I've been wanting to get it on video so that I could simply give it away, and now the time has finally come. So we're going to talk in this and at least a couple other videos about how a divorce works in the state of Texas. I'm not going to talk in this video at length about the fact that I tell you all of this information, not because I want you to get a divorce, not because I hope you end up in a divorce. I hope nobody ends up in a divorce. I hate divorces. I have another video that will explain that, but I do divorce work because I'm a divorce attorney. So for years, I've been wanting to explain to people how divorces work in the state of Texas because there's so much misunderstanding and because people sometimes suffer from the fact that there's that misunderstanding. In this first video, we're going to talk about the first part of it, which is the procedural aspects of a Texas divorce. There are the procedural aspects, and then there are also the substantive aspects. So the substantive aspects, in those videos, we're going to talk about what gets decided in a Texas divorce, really in any divorce, but particularly I'm talking about Texas because that's the state I'm licensed in. In this first video, we're going to talk about the procedural aspects of a divorce. So the very first thing to understand about a divorce is that it is a lawsuit. All divorces are lawsuits. I don't care what kind of divorce you think you're getting. I don't care what kind of marketing is out there talking to you about an agreed divorce, an uncontested divorce, a collaborative divorce, a mediated divorce. I don't care. If you get a divorce in the state of Texas, you are going to be involved in a lawsuit. It is a particular type of lawsuit, so it's a little bit different, very different, than most lawsuits in the state of Texas. The person filing the case is not called the plaintiff. The person responding to the initial filing is not called the defendant. We call them petitioner and respondent in a divorce case. So that's the first difference. But in a lot of other ways, a Texas divorce, because it's a lawsuit, is similar to other lawsuits. And the first way it is this. Because it is a lawsuit, it can only end in one of two ways. You're either going to come to a settlement or you're going to end up in trial. There is no other choice. Years ago, I used to have people that would come in for consultations, and I would talk to them and I would say, well, if you get in this situation and you're able to settle, and they'd say, oh, no, there's no way we're going to settle our case. I'd say, okay, well, then when you end up in trial, and they're like, no, I don't want to go to trial. Well, the sad news is those are the only two choices. You're either going to settle your case or you're going to end up in trial. You can settle your case through a number of different mechanisms. You can have what we call a kitchen table divorce, where it's simply the husband and wife sitting down and agreeing to pretty much all of the terms of the divorce. You can have a negotiated divorce where both sides have an attorney and the attorneys negotiate back and forth. Sometimes they trade decrees back and forth. We'll talk about that later. Sometimes they don't. You can have a mediation. You can have a collaborative divorce. There are some other forms of ADR, what we call alternative dispute resolution, that can be used, and those can end up in a settlement of the case. You can just settle at the last minute right before you go to trial. But at the end of the day, it is one of two results. You either settle your case, meaning everybody agrees that they're going to sign off on an agreed decree of divorce, or you end up in trial. Those are the only two choices. So one of the things that helps answer is this. It's not helping a friend of yours that's going through a divorce to tell them just get it over with if they tell you that the other side will not agree. If they say it doesn't matter what I offer, they won't agree to it. Well, then telling your friend to just get it over with because that's what's best for them doesn't really help, because the only way they're going to get it over with is to get it to trial. So settlement or trial, those are the only two options that you have. Another thing to remember about the case being a lawsuit is this. It has to have three parts to it. You have to have the petition, which is the initial filing in the case. It's a document that is filed with the court system. Again, it is filed in every case. I don't care what kind of divorce, what label you stick on the divorce, every divorce has to have a petition. You also have to have a decree. At the end of the case, you have a document called the decree. So it can be labeled an agreed decree of divorce, final decree of divorce, agreed final decree of divorce, whatever. It's a decree. So you have the petition, which is the document on the front end, and you have the decree, which is the document that ends the case on the back end. You have to have both of those in every case. And then you have to have a third thing. So you have to have the other person made aware of the case. It can either be done with formal service, where you have a constable or sheriff or private process server go knock on the person's door, find them sitting in their car in the driveway, catch them at work, catch them at the gym, whatever. You can have somebody served a number of different ways, but you don't have to have somebody served in every case, but you do have to make them aware of the case. So sometimes what's done is the service or the knowledge of the case by the third party is done with what we call a waiver of service, meaning they sign a document saying, I understand I have a right to be formally served, but I don't want to be formally served. Those can be used in a number of cases, but you do have to be careful if you're being asked to sign a waiver, because you got to know what it is that you're waiving. You've got to know what rights you are giving up. That's what you are doing, is you are waiving certain rights. So that's a good time to talk to an attorney if you're being asked to sign a waiver. So those are the only three things that you have to have in a divorce, but every divorce, again, doesn't matter what kind, every divorce has to have those three parts to it. So you only have to have those three parts to have a divorce from beginning to end. You do have to have those, but the other thing to know is that you can have everything that you can have in any other kind of lawsuit, meaning you can have all kinds of written discovery. You can have requests for admission, you can have requests for disclosure, you can have requests for production, you can have interrogatories, you can have requests for inspection, you can have written depositions, you can have oral depositions. There are a number of methods that can be used in any lawsuit to find out what information the other side has, what things they know, what documents they have, all of those kinds of things. So you can have all of that discovery done in a divorce case. You can have motions, just like you have in other cases. You can have motions for summary judgment. You can have motions for dismissal. You can have all kinds of motions, motion for bifurcated trial. All kinds of a motion practice can happen in a divorce case. And then the thing to be aware of in a divorce is not only must you have those first three things, also you can have all of that other stuff. And then in a divorce, you can have something that you rarely see in most lawsuits, and that is what we call temporary orders. In other cases, it tends to be referred to as temporary injunctions, but those don't happen in most cases. So, for example, in a car wreck case, if you were to, heaven forbid, get run over and injured, and you are going to have medical bills, you may be out of work, you may have all kinds of problems that you need resolved, you can't resolve those until the case is over with. Now, you can resolve them in terms of getting your medical care, but you can't get your medical care paid for by the other side by going to the court and saying, hey, judge, we know that this other person ran over me. We know that they're going to end up having to pay for this. And so what I want you to do, judge, is I want you to make them pay for my medical care while I'm getting treated, and then we'll kind of settle up at the end of the case. There's just no mechanism for doing that in a traditional case. In a divorce, there is. The thing that makes a divorce very, very different, sometimes much more costly, oftentimes much more costly, even not in terms of attorney's fees and things, just in terms of out-of-pocket money for the people going through it, is the temporary orders that are available in a divorce. So in a Texas divorce, you can have what we consider the big case, the petition at the beginning, the decree at the end, and all of that stuff we talked about in the middle. But you can also have the case within the case, the temporary orders. And so the way that works, what that looks like in a case, is the case starting, and then right at the outset, one side or the other side or both sides going into court and saying, judge, we know we're going to decide all this stuff at the end of the case, but we don't want to wait till the end of the case to have certain resolution. You can't. You've got children to deal with. You've got bills that need to get paid. You've got income that one person or the other needs to have access to. And so in In a divorce case, you can go into court with a request for temporary orders, and you can ask the court to enter a temporary order, which is really a form of a temporary injunction, and it is a court order that can dictate all of those things we're going to talk about in a later video about the substantive things in the case. And the court can really deal with virtually all of that at the temporary stage. So in the final decree, you're going to talk about ownership. In the temporary orders, you're going to talk about possession or access. And first of all, talking about property. So at the end, you're going to talk about who ends up owning a particular vehicle or a particular piece of real estate. In the temporary phase, you're talking about who's going to possess it while the case is going on, who's going to have access to it. And if you think about that with money, it's really the same thing. It's who's going to have access to what money. So the court can order temporary possession of the home. The court can order a temporary possession of vehicles. The court can order temporary possession of other real estate. And then the court can also order temporary child support and temporary spousal support. Temporary spousal support can be a real big ticket item in the state of Texas because there are very few rules on temporary support. When you get to the final decree, and we'll talk about this in another video, in the final decree, there are real strict parameters about what the court can do and not do when it comes to ordering what we call spousal maintenance in the final decree. But at the temporary stage, there are very few rules. So arguably, a court can order somebody to pay more money in temporary support than they make. And that can happen in a case because, for example, husband can come into court and say, Judge, yes, I work for myself and I only make $5,000 a month. And then the wife can come into court and say, he's lying, Judge. He makes $10,000 a month. And then the court can order that the husband pay the wife in temporary support $7,500 a month. Well, if the wife is telling the truth and it's really $10,000, then the husband still has $2,500 a month left after paying that temporary support to pay his own bills. But if the husband's the one telling the truth and he only makes $5,000 a month and now he's ordered to pay $7,500 a month, that can create a big mess and cause a lot of problems in the case. But it is possible, and it's very difficult to get that undone. But going back to the concept of temporary orders, the case within the case, when you get to the children's issues, all the things that get decided in the final decree can get settled at the temporary stage. In other words, an order in place for what's going to happen while the case is pending with respect to the children. And it can govern what happens in terms of the temporary possession of the children, temporary access to the children, temporary child support, temporary rights and duties, who's getting to make what decisions, and all of that. So those are some of the things that you need to keep in mind with respect to how a divorce works in the state of Texas from a procedural standpoint. It's a lawsuit. It's always a lawsuit. It has to have at least those three parts. It can have all of the other things that all of the other lawsuits have. And then the biggest thing to remember is that it can have temporary orders, and those happen in, I don't know what percentage of cases, but I would say more than 50% of cases that have any complexity to them at all. And oftentimes, while the big case can be settled, the temporary orders can be settled also. Another thing to keep in mind about the procedural aspects of the case is this. A lot of counties in the state of Texas have what are called standing orders. So what those are is they look kind of like a temporary order, but they don't really order people to do much. They order you or give you a list of things to not do while the case is pending. And standing orders, by their terms, go into effect from the time the case is first filed. So if you were filing the case, if you were the petitioner in a county that has standing orders, once you file, you are governed by those standing orders. You're obligated to obey those standing orders even before the other side is. Even before the other side is notified that the case has been filed. And then once they're notified, then theoretically they are under those standing orders and they have to follow those rules. So that's enough for this video talking about the procedural aspects of the Texas divorce. Look for my other videos where I'll talk to you about the substantive aspects of it, and then we'll go into a lot of other details in other videos after that. Thanks.